Well, good afternoon, everyone. The late, great Sir Kenneth Dodd, although not an expert, took an interest in psychiatry. He was fond of saying that, according to Freud, laughter is the outward expression of the psyche. But of course, Freud never had to play second house at the Glasgow Empire on a Friday night. And all I can hope as the last speaker on this Monday afternoon, you will grant me greater indulgence than those bygone music hall audiences of old. I would like to thank you for inviting me to speak today. It's a great honour to deliver a contribution alongside such distinguished speakers this afternoon. The subject is the psychiatrist as an expert witness, and I would like to look at expert evidence with a particular emphasis on qualified psychiatric evidence. Qualified psychiatric opinion does, of course, play a very prominent role in all areas of forensic activity, not just the number and range of issues that require psychiatric input, but also, of course, the fact that psychiatric opinion does enjoy a special status and recognition not bestowed on other professional disciplines. So, although the legal system requests and demands the assistance of psychiatrists in a great many situations, there is a downside from your point of view. Now, can anybody tell me who that is? Anybody? Beg your pardon? That's right. Professor Sir Roy Meadow, he was not a psychiatrist, but he was once an eminent paediatrician. And this is Sir Roy on his way to his GMC hearing for serious professional misconduct. And he gave evidence in a number of high-profile cases where parents were accused of murdering their children. Now, Sir Roy may have been an eminent paediatrician, but he was not a statistician. But that did not stop him from opining that the chance of 2 children dying naturally in these circumstances is very, very long odds indeed, 1 in 73 million. The circumstances he was referring to was the circumstances of unexplained death of 2 children in the same family. And his estimate was grossly overstated. The likelihood of 2 separate unnatural deaths cannot be squared with one another unless the events are truly independent, which is, of course, not the case with deaths in the same family. You might well ask, how is it that the court allowed this fallacious evidence to be given without being properly scrutinized? You might think that the prosecution, the defense, and the trial judge all have blood on their hands. But the whole sorry affair illustrates the risk that any person takes when coming into contact with any court. And that is, whether as a volunteer or a conscript, any contact with litigation can have profound and sometimes devastating repercussions. Public humiliation is the least of it, the complete destruction of your reputation, and in the worst cases, the loss of your license to practice. In Sir Roy's case, he was initially found guilty of serious professional misconduct, but this was commuted to professional misconduct. The short point is it is worth paying attention to the requirements imposed by the courts upon skilled witnesses. The Royal College has produced a document, College Report 193, which deals with the responsibilities of psychiatrists who provide expert opinion to courts and tribunals. And I would recommend that you, if you're involved in giving expert evidence as a psychiatrist, you should obviously look at that and the references and recommended reading which it has in an appendix in it. There is other guidance. There's no shortage of other guidance. There, as well as the guidance that I've just referred to, there is the GMC guidance, and then there is also guidance on the Civil Justice Council website dealing with the instruction of expert witnesses in civil claims. So that's just some of the guidance that is available. There are basically two fundamental requirements of any expert. It is the duty of an expert to help the court on the matters within his expertise, and this duty overrides any obligation to the person from whom he has received his instructions or by whom he is paid. Now, the important point to grasp as a doctor, I think, is that as an expert, you are now involved in a different relationship with the person that you're examining from the doctor and patient relationship. And the duty overriding any obligation to the person from whom he has received instructions or by whom he is paid also creates a potential conflict with your patient in this respect. The Royal College says that it's generally good practice for treating psychiatrists not to provide expert testimony about their patients. Giving evidence as the treating psychiatrist is not the same thing as giving expert evidence, but it's important to be clear the role that you are playing. If you're giving evidence as an expert, you're doing so in that capacity rather than as a professional witness and as the treating psychiatrist. But I would also refer you to this document which says CR 193, which indicates that you should, if you are dealing with as an expert if you're an expert psychiatrist and you are dealing with an existing patient, you should look at the question of whether you have consent from the patient, and you should consider whether there is a conflict. But the basic position, I think, is that it may be better and is better for an independent psychiatrist to provide expert evidence to the court. Now, what I want to do is to look at 6 things. I want to ask the question, what is an expert? I want to ask the question, how is expert evidence different from the ordinary evidence that's given by an ordinary witness? I want to emphasize that the decision is always for the court and not the opinion of an expert. I want to look at the duties of an expert. I want to say something about preparing reports, and then I want to look at the admissibility of psychiatric evidence in certain situations. Now, so the first thing is what is an expert? And some of you will have noticed that I have a Scottish accent, and I practice in Scotland, and the older Scots term for expert witnesses is a skilled witness. And in some ways, that more modest and less deferential expression perhaps better encapsulates the role that is played by the witness, because the witness is providing the benefit of his or her special skill for the benefit of the inquiry. I, of course, accept that the term expert is ingrained and will survive the attempts of the likes of Michael Gove and others to discredit it. The point is, we are looking at somebody with a special skill, and we need their help. So what is a skilled witness? A skilled witness is a person who, through practice or study or both, is specially qualified in a recognized branch of knowledge whether it be art, science, or craft. Clearly, medically qualified psychiatrists are skilled witnesses. So what is it that skilled witnesses do? And what are they allowed to do that ordinary witnesses are not allowed to do? Well, the main thing is to provide an opinion, because normally an ordinary witness is not allowed to provide an opinion. And sometimes it might be difficult to distinguish between what an opinion is and what a fact is. I mean, the motorbike was going, I thought, at 30 miles an hour. Sounds as though it might be a fact, but it is in fact an opinion. That sort of evidence is given all the time. But we know it when we see it. An expert is providing a skilled opinion, and in the case of a psychiatrist, the most obvious opinion would be that an individual is or was at the material time suffering from a mental disorder. The second thing that an expert or a skilled witness does is explain technical matters or terms. The third thing is to provide evidence of fact, observation, comprehension, and description of which requires expertise. So in the field of human behaviour, you may be permitted to explain why certain individuals with certain disorders might be expected to behave in a particular way. You are describing a fact, not expressing an opinion, but you require a skill to be able to do that. And then finally, the fourth thing, basic thing that an expert does, is to take account of information stemming from the work of others. This is often an important feature of the evidence of skilled witnesses, and you are obviously frequently required to do that in your professional life. You're required to look at literature. We've seen examples of that, obviously, this afternoon, and regularly that is done. That we summarize and look at and synthesize the work of others and come to a view and provide that to the court. So you're there to do one or more of these things. The one thing you're not there to do is to decide the issue for the court. The issue is for the court, and you may be permitted to explain something which is, or to give an opinion about something which is for the court to decide, but it is ultimately for the court to decide. For an illustration of the point, we'll go back to an old case involving a man called Mr. Davy, who sued the magistrates of Edinburgh in the early 50s, and he had a rather nondescript house in the outskirts of Edinburgh, which was damaged following blasting operations by the local authority, who were constructing a sewer or extending the sewage system. And there was no doubt that before the blasting, his house was intact, and after the blasting, his house was damaged, and he made a claim for compensation. And the council led an engineer who said that the explosions were far too far away from his house to have caused any damage. And that was the only expert in the case. And it wasn't contradicted by any evidence that was led on behalf of Mr. Davy. But the judge found, ignoring, or not ignoring, taking it into account, but disregarding the expert evidence that the damage had been caused by that had been caused by the explosion, and that was appealed. And then, when it was appealed, the Lord President Cooper gave what is a very famous dicta, which is quoted in a lot of cases, that expert witnesses, however skilled or eminent, can give no more than evidence. They cannot usurp the functions of the jury or the judge sitting as a jury. Their duty is to furnish the judge or jury with the necessary scientific criteria for testing the accuracy of their conclusions, so as to enable the judge or jury to form their own independent judgment by the application of these criteria to the facts proved in evidence. The scientific opinion evidence, if intelligible, convincing, and tested, becomes a factor, and often an important factor, from consideration along with the whole other evidence in the case. But the decision is for the judge or jury. In particular, the bare ipse dixit of a scientist, however eminent, upon the issue in controversy will normally carry little weight, for it cannot be tested by cross-examination, nor independently appraised, and the parties have invoked the decision of a judicial tribunal and not an oracular pronouncement by an expert. So the key words there are: it's got to be intelligible, it's got to be convincing, and it's got to be capable of being tested. And if only the courts had been more rigorous in their application of the dicta that I've just referred to, some of the difficulties with expert evidence might not have occurred. So the issue is for the court. And so the next thing I want to look at is the duties of an expert. And these were summarized in a case, as you'll see, known as the Icarian Reefer, a Greek shipping case, as the name suggests. This summary was given by Mr. Justice Cresswell in that case in 1993, and there are basically 5 duties that are given, and they now form part of the civil procedure rules that they've kind of been put into statutory form, as it were, in the civil procedure rules. So the first is that expert evidence presented to the court should be seen to be the independent product of the expert, uninfluenced as to form or content by the party instructing the opinion. Second, an expert witness should provide independent assistance to the court by way of objective, unbiased opinion in relation to matters within his expertise. An expert witness should never assume the role of advocate. And third, an expert witness should state the facts or assumptions on which his or her opinion is based. He or she should not omit to consider material facts which detract from his or her concluded opinions. Fourth, an expert should make it clear when a particular question or issue falls outside his or her expertise. And then, if an expert's opinion is not properly researched because she considers that insufficient data is available, then this must be stated with an indication that the opinion is no more than a provisional one. So those are 5 basic requirements or duties that any expert called to give evidence of whatever discipline is required to observe. Now, in relation to psychiatrists, it's fair to say that psychiatrists take a different or have a different view from lawyers, or there is a different mindset. One way of summarizing it is that psychiatrists look at mental disorder from a dimensional point of view. Lawyers take a very legalistic or categorical approach, and it's either one thing or the other. The key point, I think, is that the psychiatrist who's asked to give an opinion or to provide expert evidence, before doing anything, must understand the question that's being asked and the legal test to be applied to the question. Sometimes the fault is not with the psychiatrist. In fact, very often is not with the psychiatrist. The fault is with the lawyer. The lawyer sometimes does not make it clear what question is being asked. So if you're asked to give an opinion, and you don't understand the question, or you're not clear about what the question is, then don't be afraid to ask for clarification. Don't accept anything other than clear instructions. Make sure you have the basic information. Find out what the nature of the precise expertise is required. Is it actually within your expertise, or is it somebody else that would be better to deal with it? Find out what the purpose of the advice is and the details of the proceedings for which the advice is sought. These are all basic things that have to be done at the point at which you're instructed. The key point is understanding, I think, what the nature of the question the lawyer is seeking you to answer, and you have to understand the legal context of that in order to give the skilled evidence, address the question that's being asked. In terms of preparation, there are the four R's apply here. The first R is retain. You should retain everything, including physical, written, and electronically captured material until otherwise instructed. In other words, as soon as you do any work on anything, you should retain any material that you have, because that may be required for disclosure purposes. The next R is record. You should keep records of all of the work you've carried out and any findings you make in relation to the investigation. The requirement to record begins at the time you receive instructions and continues until the end of your involvement in the case. The next R is reveal. You must be in a position to provide all relevant material and have in your statement of report, and your records should be capable of being made available to the other side if requested. And finally, review. You should review your conclusions if any new information comes to light, both before and after any trial or appeal. So those are the four requirements in terms of preparing or carrying out any work in the field. They would apply to any expert from any discipline. In the context of a psychiatrist, I suppose having notes of the consultation and retaining those notes, if there is any dispute about what was said or whatever, might be one of the things that's important to be capable of being reproduced. So the next thing I want to deal with is reports. And I'm going to say something about what is required in relation to reports. Just some basic points. Use plain English and provide a glossary of medical terms. It's always helpful to have that for the layperson looking at the report. Try to use a structure and follow a structure. I suppose those of you who regularly prepare expert reports will have your own approach and deal with this in a particularly structured way. But if you're new to it, then try to develop a structure that works. And the third thing is to be as concise as you possibly can. Sometimes, obviously, it's difficult to write a short report, but if time is taken to cut down the redundant verbiage and to try and be as concise as possible. So I want to look just at some requirements of what reports have, or what the requirements of reports this is in the criminal sphere, but actually it's a useful checklist for reports generally. I don't think there's anything here that wouldn't be necessary or desirable, at least in other contexts. The criminal procedure rules, I should say, Part 33, are a set of rules that demand certain things for the expert report to have. So, in terms of those rules, you've to give details of your expert qualifications, relevant experience, and accreditation. Give details of any literature or other information which you are relying on. And then contain a statement setting out the substance of all facts given to you which are material to the opinions expressed or upon which those opinions are based. In relation to facts, you should always be aware of accepting a history at face value. Always obtain, or as far as possible, obtain medical records. Sometimes the subject's perception about what has happened is different from that which is recorded, and it's important that that material is available. And I think it's probably important that that material is available before you express an opinion. So having all the medical records, the pre-accident in a personal injuries case medical records, for example, the pre-incident or the pre-index event medical records are useful to have, or I would suggest they're really indispensable before an opinion is expressed. make clear which of the facts stated in the report are within your own knowledge. And then where there is any examination or measurement or test or experiment which has been carried out, give the qualifications and relevant experience of any other person who's carried that out. Now, these next three are probably not so often encountered by the psychiatrist, but it may be that somebody else has carried out certain work. So you've got to give out the qualifications of that person and summarise the findings on which which you're relying upon. Where there's a range of opinion on the matters dealt with in the report, summarise the range of opinion and give reasons for your own opinion. And if you're not able to give an opinion without a qualification, state the qualification. Include such information as the court may need to decide whether your opinion is sufficiently reliable to be admissible as evidence. Contain a summary of the conclusions reached. Contain a statement that you understand your duty to the court and you've complied with that, and a declaration of truth as to the witness statement. Now, those are the English criminal procedure rules that I'm referring to there. The final section of my contribution this afternoon concerns the evidence of human nature and behaviour and the rule in R against Turner. And the point here is that psychiatric evidence is used in many situations, but sometimes the courts restrict the ambit of your contribution or the ambit of the evidence that you can give. Referring back to CR 193, at page 22, it states, and I quote, "The expert should not take instructions that go beyond psychiatric expertise and evidence-based data. For example, responding to a request to determine whether an individual is telling the truth or diagnosing a novel psychiatric condition for which there is no evidence base." And that quotation is a reference to some extent to the rule in R against Turner. Now, R against Turner was a Court of Appeal decision in 1975, and it was Mr. Turner was prosecuted for murder. He admitted that while sitting in a car with his girlfriend, he had battered her about the head and face with a hammer 15 times. He argued that he was provoked and sought to reduce the charge of murder to manslaughter. He said that while he'd been in the car with his girlfriend, she had told him with a grin that while he'd been in prison, she'd been sleeping with 2 other men, and that she could make money this way, and that the child that she was carrying wasn't his. He claimed to be very upset about that, and that his hand had come across a hammer which was down the side of a seat, and he had hit her with it 15 times. Now, after Mr. Turner had given his evidence to that effect, the defence sought to call a psychiatrist. A Dr. Smith had prepared a lengthy report, and the author stated that he'd been asked to assess the defendant's psychiatric personality, his present mental state, and to consider from a psychiatric point of view his emotional state and reaction at the time of the crime. And the report contained a long account of the defendant's personality, medical history, and family background. And the report contained the following passage, that from all accounts, his personality has always been that of a placid, rather quiet and positive person who is quite sensitive to the feelings of other people, regarded as even-tempered, not aggressive, and displayed remarkably good impulse control. That last passage came as a surprise to the prosecution because Mr. Turner had convictions for assault with intent to rob and for possession of an offensive weapon. And the psychiatrist gave an opinion in which he said that there was no evidence of mental illness, that the homicidal behaviour was understandable in terms of his relationship with his girlfriend, particularly vulnerable to be overwhelmed by anger if she confirmed accusations made about her. If his statements are true, he was taken by surprise and would have appeared to have killed her in an explosive release of blind rage. His personality structure is consistent with someone who could behave in this way. There was no evidence of brain damage or organic disease, and following the death, he had suffered from profound grief, but there were no indications for recommending any psychiatric treatment. Now, what had happened at the trial was that the trial judge had refused to allow the psychiatrist to be heard. The evidence was inadmissible, and Mr. Turner was convicted, and then he appealed to the Court of Appeal, and in the course of that, the rule by Lord Justice Lawton, or the dicta as follows, was that an expert's opinion is admissible to furnish the court with scientific information which is likely to be outside the experience and knowledge of a judge or jury. If, on the proven facts, a judge or jury can form their own conclusions without help, then the opinion of an expert is unnecessary. In such a case, if it is dressed up in scientific jargon, it may make judgment more difficult. The fact that an expert witness has impressive scientific qualifications does not by that fact alone make his opinion on matters of human nature and behaviour within the limits of normality any more helpful than that of jurors themselves. But there is a danger that they may think that it does. Jurors do not need psychiatrists to tell them how ordinary folk who are suffering from any mental illness are likely to react to the stresses and strains of life. And then he goes on, psychiatry has not yet become a satisfactory substitute for the common sense of jurors or magistrates on matters within their experience of life. Now, I can see that this passage is, it is from the 1970s, and there was a tendency, or there was a beginning of a tendency for defence counsel to seek to camouflage criminal behaviour with pseudoscientific explanation, but it has been quite trenchantly criticised since, and it has not been applied to the extent that perhaps Lord Justice Lawton might have liked over the years. The criticism of it can be broken down. There is, of course, no clear line between normal and abnormal, and experts often needed to make that distinction. Second, common sense, whatever that is, may not be an adequate substitute for scientific understanding. And third, a third possible criticism is that it's wrong to assume that experts only concern themselves with abnormal people, as the contribution on post-traumatic stress disorder, I think, possibly illustrates. But the decision on its facts was correct, and the decision is not perhaps as restrictive as it appears at first sight, because the court did say that in coming to the conclusion we have in this case, we must not be taken to be discouraging the calling of psychiatric evidence in cases where such evidence can be helpful within the present rules of evidence. In the actual decision itself, the psychiatrist who was going to give evidence, there was nothing obviously scientific or expert about the evidence that was being given in the particular circumstances of the case. But there have been a number of important departures from, or developments in recent years, or since the decision. One, I'm just going to give you a few examples of and they're not comprehensive, and it's just an illustration of the examples. One is the evidence of subsequent behaviour in sexual abuse cases. So victims of sexual abuse are often criticised for not coming forward either after the event or disclosing in incrementally. And there is good evidence and psychiatric evidence and psychological evidence is allowed to show that that does not necessarily mean to say that what they say happened to them. So that's one statutory exception to the rule that I've just been talking about. Battered women's syndrome is another, that the situation where for no apparent reason, a woman does a very serious injury to her partner or husband, perhaps even murders him, but that is explained by events which have not been the subject of an immediate provocation, but have gone back in time, and that is another situation where expert evidence has been admitted. Childhood amnesia, there is an example from the Court of Appeal where, in a case of alleged sexual abuse of a young child, the Court of Appeal allowed evidence on behalf of the defence that an adult's memory in childhood is likely to be unreliable if it's too detailed. False confession evidence, the suggestibility of confessions, where there's low IQ, not subnormal, but above the threshold, if you like, that's still been allowed. And then false memory, where you have a pathological liar, where there's actually a diagnosable medical condition. The court has, in the United Kingdom, has said that that is admissible. So there is clearly room for development in this area, but it is important that it is psychiatric evidence which is based on evidence-based data, and it is important to be aware of the potential issue that might arise where you're dealing with an opinion in relation to human behaviour, evidence about human behaviour. So, in conclusion, I think what I'd like to say is that although I began with a cautionary tale, it is important that everyone involved in the administration of justice faces up to the challenges posed by obtaining the best evidence from skilled witnesses. And I hope I've set out in outline what those challenges are in relation to psychiatric evidence, and at least pointed you in the right direction. Thank you.